Show them.
Yeah. Let me pick them.
Because I can't see myself. I can't see.
Here, let me.
So how will people know where to go?
Because it's
No, it's the same thing. It's the same thing. You're just gonna
The same
look for you in
channel?
the same place.
Uh-huh.
Yeah.
The same YouTube channel?
Yes, we're just not using this cameras anymore. We're using your phone. You're live.
So are we live now?
Yes.
So can we get the questions, the login,
Yes.
all those things?
Okay. Then, yeah.
Okay. So are we live now?
Yes.
So can we get it's kind of dark.
Okay. I think it's your phone, maybe. 'Cause this
Oh,
one
is
looks
it?
good. Yes. Maybe you can increase
So are we
it.
live now? Yes. So can we get it's kind of dark.
Yeah, I think it should be. I think it's your phone. Okay, remember you need to lower the volume on that phone. Yes.
Yeah, I was already off.
Yeah.
Oh, okay.
Yeah. You don't hear yourself.
Okay.
People can hear you.
Yes.
But are people back on now? Because
There's
many
two
people.
now. There are 2 people now.
Okay.
And I'm going to post the new link.
Please. I don't know. I'm not able to. Is it the phone or maybe I should log off of the
No, go to.
Wi-Fi? Maybe I should use the phone.
Uh-huh. Okay, so the chat will appear on the screen.
Yes, as you talk,
So-
people will see you.
Yeah.
Well, you will see people's comments. Ask if they can hear you now. Instead.
Hello, everyone. Can you hear me now?
Yes, we can.
Okay, you can hear me. But something is wrong. I still cannot. It's just rolling on my phone, even though I've turned on the. Please play with it if you can get it out.
What do you want?
To be able to see the questions.
You're there.
They'll come up on the screen.
They will come up.
What about the screen rolling?
Oh, don't worry about it. Don't worry about it. It's maybe because you have the. I don't know, but you can see people talking.
Okay. Good afternoon, ladies and gentlemen. We apologize for the technical difficulties. I mean, machines will always be machines. I mean, there was no indication before now that we will have issue with the audio, but apparently listeners were unable to hear us. So eventually we have to improvise. So we are using our cell phone now to go live. So it is important that you can hear us. Today we are starting detention series. Is that the topic?
Yes.
Okay. We are starting detention series. This series is going to be, we are going to have multiple podcasts on detention. So today we are going to start from how somebody can get into detention, immigration detention, and what can be done if you get into immigration detention. There are several ways to get into immigration detention. The first one is maybe when somebody apply for some benefits that are denied. It is not when every benefit are denied that it can lead to removal proceedings, but there are some specific benefits that the consequence of a denial is a mandatory removal proceedings. Example of such benefit is application for asylum. If an affirmative application for asylum, that is, application for asylum is filed with USCIS, if USCIS is unable to approve that application, then it is mandatory that USCIS must place that person in removal proceedings so that the person will have the opportunity to represent his or her asylum application with the immigration judge. So in such a situation, it is mandatory that the person will end up in removal proceedings. Another way somebody can get into immigration, but before I go into the second way, I want to clarify that if somebody file an application for asylum and that application is not approved by USCIS and that person is placed in removal proceedings, that does not trigger detention. That does not trigger detention. So I want that to be very clear. That only trigger removal proceedings, but it does not trigger detention. However, it can trigger detention where the applicant enter the United States without a visa, maybe enter through the border, either through the airport or through the port of entry, driving through the border. And then if this person apply for asylum at the border, such a person will still be detained. So that is one way that asylum application can lead to removal proceedings. Is there any problem? That is one way that such asylum application can lead to removal proceedings. In other words, if you apply for asylum through the border or through the port of entry, through the airport, or any means of entering the United States, you will be detained pending what we call credible fair interview. Now, when somebody attempts to enter the United States through the port of entry, through the border, and the person have declared intent to apply for asylum, saying that he or she is unable to return to his or her home country due to fear of persecution or due to past persecution, immigration officials or ICE officials or CBP officials, as the case may be, will detain that person, and then they will invite an immigration officers who are specialized in conducting what is called credible fair interview. Then they will come in and meet the applicant at the detention, and they will conduct what is called credible fair interview. Upon the credible fair interview, the officer will make an assessment, and if there is a credible fair determination, the applicant will be encouraged or will be instructed to formally apply for asylum by completing application for asylum within 1 year from that day that the applicant was detained. Now, if the applicant is also found to be credible, the applicant may be released on parole. Now, if an applicant find himself or herself in the position of parole, that actually gives a very unique positive benefit, because someone who entered the United States illegally without a visa, if that person is paroled at the port of entry, the parole will have the same exact uh, uh, the same the same use as somebody who entered with a visa. The parole will have the same benefit, will have the same force of law with somebody who entered with a visa. So it is possible for somebody to come into the US without a US visa, coming through the port of entry, declare intention to apply for asylum, will go through credible fair interview. If ICE or USCIS or CBP officials, if they made a credible fair determination and then parole the applicant, that applicant can actually adjust status even without going through the asylum. That applicant can now use the parole. The parole will serve it will have the equal force of law as somebody who entered with a visa. So that is one of the advantages. Now, another way somebody can get into immigration detention, and the most popular way, is to commit an offense. Now, I'm not even talking about conviction here. Whenever somebody is arrested, there is an unwritten law about an understanding between every police department in the United States and ICE. ICE is Immigration and Customs Enforcement. So what that means is that once somebody is arrested, and then they conduct fingerprinting on that person, and they check that person's immigration status. If that person is not a US citizen, if that person is not a permanent resident, or if that person does not have legal stay in the US, that will trigger a hold. That will trigger ICE hold. ICE hold means that the police department will place a hold on that person and then contact ICE that, oh, we have this person in our detention and we have checked this person is not a US citizen. So they will place a hold. Although the police are not involved in the enforcement of immigration law, but they will transfer that person to ICE, which is Immigration and Customs Enforcement. They are the one that will now conduct the immigration proceedings on that person. So once ICE places a hold on the person, even if that person posted a bond for the criminal arrest, the police department will still not release that person. But it is important also to pay the bond, because if that person does not pay the bond, the police department will not even transfer the person to ICE. So the person will just be languishing in jail. And that is one of the main reasons why we are doing this topic today, because we know so many people who are just languishing in jail. If you are arrested and there is a ICE hold on you, if you think that, oh, because there is a ICE hold, there is no point paying the criminal bond or the police bond, you are making a big mistake, because they will not transfer you to ICE custody until that bond has been paid. So generally, if you are in that situation, go ahead and pay the bond. As soon as you apply for the bond and pay the bond, then they have a mandatory duty to transfer you to ICE. At that moment, if you have a lawyer, contact your lawyer immediately, so that when ICE process you, the lawyer can get you out on bond pending your immigration proceedings. Now, if you don't have a lawyer, there are two things that you need to understand when you get into immigration detention. Two things are vital. Number one, make sure that once ICE process you, note your alien number. There is nothing anybody can do to get you out if you don't provide your alien number. Immigration does not use name or date of birth to identify foreigners or anybody at immigration detention. The only thing they use is the alien number. So make sure that you know your alien number. So, because even if you engage a lawyer, if you don't know your alien number, there is no way the lawyer is going to be able to do anything. The lawyer will not be able to assist you. So it is very, very important to know your alien number, and to also know who is in charge of your detention, who is the deportation officer in charge of your case. Of course, lawyers will find out that even if you don't know that, for as long as you know the alien number. But without the alien number, lawyers will be helpless. They will not be able to do anything. So that is another way somebody can get into immigration detention. Thirdly, another way somebody can get into immigration detention, and this is also fairly common, when somebody has been ordered removed, either after a trial or a removal in absentia by an immigration judge. That is another thing that triggers immigration detention. One thing we need to understand is that America is a country of law, and every law here must be enforced. Once an immigration judge gives an order that this person should be removed, whether you have knowledge of that order or not, the order remains in force. So every opportunity that the law enforcement have, they can always enforce that order. You can be stopped by the police just for mere speeding. You could be stopped for mere traffic check, and then as soon as they run your background, if they see that there is a pending removal order against you, right there the police is going to contact ICE, and ICE is going to have to pick you up. That is another way, and it is, like I said, it is very, very common. A lot of people, when they get a notice to appear, or when their case is denied, or when they file an application that require a review by the immigration judge, while that NTA has been issued, but before the NTA is filed in court, most people will have moved, most people will have changed their address, and they will not notify immigration or notify the court. So at the end of the day, by the time the court send you a hearing notice, if you don't receive the hearing notice because you didn't know, because you have changed your address and you didn't notify the court, on the day of the hearing, the court is not going to wait for you. For as long as there is documentary evidence in the record that the hearing notice was mailed to you, whether that notice was returned or not, or whether it was actually received by you, is immaterial. The only evidence the court is going to consider was this hearing notice mailed to you. Once they have that record on file, the judge is going to order you removed. I've seen this happen over and over and over again. People who have been ordered removed and they did not know about it. I've seen in this situation, if you have a removal order, as I said previously, you could be stopped. A mere traffic stop can lead you to being detained. If you didn't know about it, maybe you subsequently married a US citizen who filed a petition on your behalf, and you appear for interview at immigration office, you could be detained. Because once the order has been given, that order remains in force until it is executed. And every opportunity that they have, they will implement it. Another way is that even if you are not arrested by immigration during an interview, even if you are not stopped by the police for any traffic stop or anything, even if you do not have criminal record or anything, the fact that there is a removal order against you, ICE officers can actually look for you specifically to try to implement that order. They can pick you up at work, they can pick you up at home, they can pick you up on the street, they can pick you up anywhere, because for as long as that order is in existence, the order remains active. And until the order is implemented, it remains active. You could be arrested at any time. So that is another thing that creates a situation where somebody can be arrested. I've seen a lot of people who erroneously believe that if you have a removal proceedings, if you relocate from one state to another, they will not know about it. My friend, that is not true. That is misinformation. It does not matter where you go to. It does not matter where you live. Once that order has been given by the immigration judge, the order becomes active and it doesn't expire until it is implemented. The order can be active for 20 years. Whenever they see you, in fact, before the United States Department of Homeland Security was created, in the days of INS, when a lot of government agencies do not communicate with each other. I have seen a situation where somebody was ordered removed in California. That person relocated to Texas. At that time, because the government agencies were not sharing data, they were not sharing a lot of things, the person eventually married a US citizen in Texas, and that citizen filed a petition on his behalf. The petition was approved, and because the immigration office in Texas was not aware of the California order at that time, they approved the green card. But guess what? Because that order remains active, by the time this person became eligible to apply for citizenship, by that time, all the databases have been linked together. The Department of Homeland Security has been created. Now they are able to see everything that is going on in the entire country. So by the time this person appeared at the interview for citizenship, he was picked up based on that order of several years previously from another state. So in today's America, it does not matter where you live. It does not matter whether you move from one address to the other. Once the order of the immigration judge is issued, that order remains active and it can be implemented at any time. It does not expire. Now, I think we should have a lot of questions. So let me see if we have questions. Okay, I can see that we have questions. Okay. Okay. First question. Question from one of our viewers. If ICE comes to my door, I refuse to open the door. What are the consequences? Okay. This is a very, very good question because today we are discussing detention. If ICE comes to your door based on a removal order that they are trying to implement, if you don't open the door, they could break the door. Remember, this is enforcement. This is different from when USCIS is conducting investigation. There are two different things. You need to understand when we are talking about immigration, there are three basic agencies. We have United States Citizenship and Immigration Services. Those are the ones that review applications and adjudicate applications. They also have a department that conducts investigation. So if they don't believe if you apply for a benefit and they have a doubt about your eligibility, they could come to your house to conduct investigation. Even in employment-based cases, they could visit the employer to conduct investigation. Those are USCIS officers. For those kind of officers, if they knock on your door and you don't open, there is nothing they can do. It is within your right not to open the door to them. It is also within your right to open the door for them and refuse to talk to them. You have the right to remain silent. So you can even tell them, I'm sorry, I don't want to talk to you today. There's nothing they can do. They cannot arrest you. Those are USCIS officers. Now, it is different because we are talking about detention here. If those ICE officers, if they come to your door based on a court order that you have been ordered removed, that one is different. You don't have a say in that one. You cannot refuse to open in that one. And if you do, they can break the door because that is enforcement. That is enforcing the immigration law, and you cannot stop them from doing so. In fact, if you prevent them from carrying out the order, that can also constitute additional criminal charge against you. You could be charged with maybe preventing lawful officers from carrying out their duty, lawful duties. You could be charged with there are so many criminal charges you could be given. So that is completely different. So I don't want my listeners to be under misunderstanding or misconception that, oh, Dr. Asekun once said that if they come to your door, you don't have to open the door. Yes, for USCIS officers, if they are conducting investigation. But for ICE officers, if they are there to enforce a law, you have to cooperate. If you don't, it becomes a criminal offense in addition to whatever order they are trying to implement. The next question: what am I right if I'm detained by immigration authorities? Well, let me say this. Non-citizens, they are known as aliens, but I prefer to call them foreigners. Foreigners do not have the same right as American citizens. If you are detained, you do not have a right to a lawyer. If you need a lawyer, you will have to engage a lawyer yourself. It is different from US citizens. For US citizens, yes, they will have a right to a lawyer. So if they cannot afford one, the government will have to appoint a lawyer for them. Also, in criminal cases, whether you are a citizen or not, if you don't have a lawyer, the government will have to appoint a lawyer for you. But we are discussing immigration cases here. Under immigration law, you don't have that right. So if you are detained, it is your responsibility to get your own lawyer, to find your own defense. The government is not going to do it for you. The government is not going to do it for you. So you have to find your own defense. You have to find your own lawyers. But the only thing is that if you are detained, make sure you know your alien number. Very important. Make sure you know your alien number and make sure you contact an immigration attorney as quickly as possible. There have been situations where people are deported before they even have the chance to talk to a lawyer. Let me give you I don't know whether I should say a testimony or an example of a recent case that happened in our office last week. This person was detained by immigration. Upon being detained, he indicated intention to apply for asylum and he was detained. They told him that they will bring an asylum officer to the detention to come and conduct credible, fair interview. Now, the family immediately contacted me and retained my services. So as soon as my services was retained, I contacted the detention center and I submitted a G28 for them to know that this person has a lawyer. I also scheduled an appointment to talk to the client on a secure attorney-client telephone conversation because this client was detained outside of Dallas, so I couldn't go there in person. So I scheduled an appointment with the client and I spoke to the client over the phone. I instructed the client, even though I've already filed G28, that the client should let the officer know that he has a lawyer and should give them our contact information. So I also sent an email to the detention officer saying that anytime they are ready to conduct credible, fair interview, they needed to contact my office. Few days after, the client family called me that they told them that the client has been scheduled to be deported that day. I said that is not possible. I already entered appearance. So immediately I contacted the detention center. They confirmed that the client asylum has been denied, that they found that the client is not credible. They have already denied it. I said, you cannot do that. We specifically requested, we entered appearance and we requested that credible interview must be conducted in our presence. So doing it without us is not in accordance with the law. And then I sent an email to that effect. They responded to the email that it is the responsibility of the client to tell them that he wants the lawyer to be there, that if the client didn't tell them that, that's not their own problem. So in this case, the client didn't tell them, so the interview has been conducted, the client has been found not to be credible, and the client is scheduled to be deported that same day. Now, this is where experience came in. What did I do? I went on to submit application for asylum that same day, and I filed it online so as to be able to generate the receipt immediately. So as soon as I got the receipt, I emailed the receipt to the detention officer, letting them know that, look, this person has a pending asylum application and cannot be deported until that application is adjudicated. So at the end of the day, the deportation officer was very angry, of course, when he got the notice. So he called my office, say, why are you doing this? Why are you preventing this person from being detained? I said, why did you also conduct the interview without our knowledge when we entered appearance and we told you that this person has a lawyer? Now we have filed application for asylum. You have to wait for the application to be decided. He said, oh, the application has already been denied. I said, no, what was denied was credible fair interview, not application for asylum. Now we have a pending application for asylum. It is within the client's right to have that application adjudicated. He said, oh, the application has already been denied. I said, which application? I just filed the application today. So which application was denied? That's not possible. So I said, go and check with your superior. This is not possible. We have a pending application for asylum. The application has to be adjudicated before you can remove this client from the United States. So he said, okay, what I'm going to do, I'm going to put a note that you want an immigration judge to review their decision. I said, that is fine. Whatever you do, my concern is that this client cannot be deported until this asylum application is adjudicated. So at the end of the day, they had to drop the plan to deport that client. So if that client didn't have a lawyer or didn't have a good one for that matter, that client will be out of the US today, because this incident I just told you happened just last week. So those are some of the benefits when you are in detention. Get your alien number and quickly contact an immigration officer. That is very, very important. Now, the next question. How long can immigration authority detain me? Well, there is no time limit. There is no time limit. Even though there are some cases that says that if you have a removal order, immigration have up to 180 days, 6 months, to either remove you or release you. However, there are some cases that triggers mandatory detention. For example, if you committed aggravated felony, it triggers mandatory detention because an immigration judge cannot give you bond. It is mandatory detention. There are some other cases too that triggers mandatory detention. Maybe cases involving Adam Walsh Act, sexual offense cases, cases involving minors. All those cases can trigger mandatory detention. So there is really no time limit for mandatory detention. You could be detained for years. And this is why some people, out of frustration, after being detained for several months, they will just tell immigration, you know what, just deport me, I want to go home. So there is no time limit. So you need to understand that. But if a case does not involve mandatory detention, then the applicant can apply for bond from ICE. And if ICE deny it, the applicant can apply for bond at the immigration court. The next question. Can I contact a lawyer while detained by immigration? Oh yes, I've already said it. But the first thing you need to pay attention to is to know your alien number, because without your alien number, there is nothing the lawyer can do. But yes, you can contact a lawyer. The next question. I crossed the border from Mexico and I was detained. Can I apply for asylum while I'm detained? Oh yes, you can apply for asylum, and when you apply for asylum, it is mandatory that immigration will conduct credible, fair interview on you. And if they found you credible, they may either parole you or release you on bond. If they parole you, it gives you additional benefit. But if they release you on bond, you are only stuck to that asylum application. The next question: can I request bond while detained by immigration? Oh yes, I think I've already answered this. You can request bond from ICE, and if ICE deny you, you can request a bond redetermination by the immigration court. The next question: how often will I have court hearing while detained by immigration? Now, let me say this. Detained cases are given priorities. They don't detain people. Immigration hearings are much faster when somebody is detained. Remember, your detain is costing government money. When they detain you, they have to keep feeding you. If you are sick, they have to take care of you. If they take you to the hospital, they have to pay your bills. I mean, it's not free. For you it may be free, but for the government it is not free. It's costing taxpayers a lot of money. So they usually don't allow detained cases to suffer all these unreasonable continuances and all of that. Usually detained cases, when the court is going to continue it, they give you a date within 2 to maximum 4 weeks reschedule. They don't do the years the way non-detained cases are. The next question: what happens if I'm detained by immigration but have permanent resident? What happens if I'm detained by immigration but have permanent resident? Well, usually for a permanent resident to be detained by immigration, there are only two conditions. Either the person re-entered the US and was detained as an arriving alien. And arriving alien is another example of a mandatory detention. Arriving aliens are not entitled to bond. So if you are a permanent resident, maybe you previously have criminal record that you are convicted of after you became a permanent resident, but because you have not applied for anything with immigration, so immigration may not know about your arrest or conviction. Now, if you travel out of the US with your green card and you are trying to re-enter the US, as you are coming back, if they pull the record, if CBP pulls the record and see your conviction, then they will detain you as arriving alien. In that situation, you are not entitled to bond. So there is no bond. You are going to be detained. But because you are a permanent resident, they will also adjudicate your case very quickly. So they will place you in removal proceedings, and then if you appear in court, if you have a relief, you will present your relief at the immigration court. If you don't have a relief, you may be deported from there. But that is another example of a mandatory detention situation. So now, there are only two ways that a permanent resident can be detained. One is this arriving alien. If you committed a crime after you became a permanent resident and you travel out of the country and you are coming back, you could be arrested as an arriving alien. That is one way. The second way is that if you committed an offense as a permanent resident and that offense is aggravated felony. So if you are detained, the police department will notify immigration and they will place a hold on you. So that is the second way to be detained if you are a permanent resident. So both ways, you will see it is only linked to crime. So commission of a crime is the only way a permanent resident can be detained in the United States. The next question: can I apply for any relief or benefit while detained by immigration. Oh yes, if you are detained by immigration, they will place you in removal proceedings. And when they place you in removal proceedings, that is when you will have the opportunity to apply for a relief. There are some situations, although very limited, where being in removal proceedings will actually be a benefit, because it may give you the opportunity to apply for a benefit that ordinarily you will not be able to apply for with USCIS. The next question: is detention the same as deportation? No, they are not. Detention is when you are detained by either USCIS, CBP, ICE, or the police department. There are only 4 ways to be detained. You can be detained by ICE, that is Immigration and Customs Enforcement. You can be detained by CBP, especially if what led to your detention happened at the port of entry or at the airport or at the border. 3, you can be detained by USCIS if you have a removal order and you go back to their office and they see that you have a pending removal order against you. They can detain you and then invite ICE to come and pick you up. And generally, if you are arrested by the police and you are not a citizen and you are not in legal status, they will place a ICE hold on you, and then you could be detained until ICE pick you up and transfer you to their own detention facilities. So deportation, on the other hand, is the same thing as removal. So that means that you must have gone through the process. Your case must have been denied by USCIS. Your case must have been denied by immigration court. And if you go through the appeal process, the Board of Immigration Appeal must have confirmed or affirmed the deportation order. So after exhausting all the legal process, yes, that is when somebody can be deported. So detention and deportation, they are 2 separate things. The next question: can you get an immigrant out with a normal bond person? No, because immigration bond is different from criminal bond. For criminal bond, you only pay a part of the bond amount, and then you'll be making monthly payments to the bond company. But for immigration bond, you have to pay the entire amount. So if your bond amount is 5,000, you have to pay the entire 5,000. So the reason a lot of bond companies don't do immigration bond is that if they pay the bond in full to immigration, and then if you disappear, if you run away, they lose their money. Unlike a criminal case, for a criminal case, they can just ask you to pay 10% of the bond amount, because they are not going to pay anything to the government. They are going to keep that 10%. The only thing is you will be paying them. They give the government guarantee that you will show up in court. But for immigration cases, because they have to pay the full amount to immigration, and they are not sure whether you will run away or not. So if you run away, they lose their money. So that is the difference between immigration bond and criminal bond. The next question: do the officers ever just tell you a bond amount, or do you have to request for bond? Well, it works both ways. If your case does not involve criminal matters, and if in the course of processing you, if immigration realize that you have a benefit that you may be entitled to, on their own, they can offer you a bond. I mean, there have been situations where clients are detained, and by the time we get to the detention officer, they will tell us that a bond amount has already been set. For example, let's say somebody has been detained and this person is already married to a US citizen. Maybe the US citizen has already submitted a petition, but maybe you don't have the receipt notice to show it to them, or maybe you have not even filed the petition at all, but you are already married to a US citizen. So they know that you have a potential benefit. So on their own, they can set a bond amount. But in most cases, maybe 70% of the cases, you have to apply for bond. And when you apply for bond, they will set the amount. And if they deny the bond, you apply to the court and the immigration court will set the bond amount. The next question. Oh, this is just a comment. Well, positive comment. Thank you. He said Dr. Asekun is so intelligent and knowledgeable. Thank you. Thank you for the encouragement. The next question. Questions received. Oh, I see intervention. Is that in connection to? But is it in connection with a question?
I think it's when you were discussing the case of our client.
Oh, okay.
You had to intervene to want him not to be deported.
Okay, okay.
I think.
Okay, so the next question. Who is eligible for immigration bond and how is the amount determined? Well, like I said, the amount is at the discretion of either ICE or the immigration judge. You are eligible for bond if you have a potential relief, you are eligible for bond. 2, if your case does not involve mandatory detention, you may be eligible for bonds. Those are the 2 conditions. The next question. Do you have to have a relief benefit pending to get immigration bond? No, not necessarily pending. You can still get a bond even if you don't have anything pending. You can also still get a bond even if you don't have a relief, for as long as you present a reason why you should get a bond, why they should give you a bond. Let me give you an example about that. I recently handled a case. I mean, when I say recently, this is probably within the last 2 months or so. This person was ordered removed in absentia. He didn't know that there was a removal order against him because he didn't show up in court. But luckily for him, he got to know about it within 30 days of that order. So he rushed to my office. I have this order. What can I do? Please, I need help. So I pulled the case from the court and I realized that it was ordered removed in absentia. So that means that I have to file a motion to reopen within 90 days of that order because anyway, in absentia order is one of the exceptions to the 90-day deadline. But we still have to file a motion to reopen because there's already an order. That order is not going to disappear by itself. So there has to be a motion to reopen that will be approved by the immigration judge. So now in this case, because there is already an order of removal, now if you are going to apply for a motion to reopen, it is important that you must have a relief because you are telling them that, okay, this case should be reopened. You didn't come to court because you didn't know about it. If you knew about it, you will have come to court. You have no reason to not appear in court anyway because you have this relief that you will have applied for if you had been informed. So while consulting with that client, he told me that he is single. So he has a fiancé who is a US citizen. So the fiancé, they were going to get married. So they were actually planning the marriage and all of that. So I told them, okay, if you get married within the 90, you get married first, I will come back and file the motion to reopen after your marriage so that I can present the relief of petition on your behalf and adjustment based on the approval of that petition as a relief that you will be seeking in the future. So we agree on that. He came to my office. I can't remember whether he came alone or with the fiancé, but we had that agreement. Then weeks after, he came back to tell me that he broke up with the fiancé. So what that does is that removed the relief. Now there is no relief. So what do we now rely on to tell the court to reopen the case? But here is what I did. I told the court that, look, the client didn't get a notice on this case. That was why the client didn't show up in court. If the client is given an opportunity, he will come to court and apply for relief. There are so many relief that the client could apply for. The client may be eligible for withholding of removal. The client may be eligible for protection under CAT, Convention Against Torture. But whether or not we are going to apply for any of this, the case has to be reopened first for us to present whatever relief we want to apply for. By the way, this client also has a fiancé who is a US citizen. Who knows? They may get married and the client, the now spouse may file a petition for. So there are potential relief. So based on that presentation, the judge reopened the case. So the motion to reopen was granted. So even though there was basically no relief, but we were still able to get the case reopened. But at least once the case has been reopened, the fear or the probability of being arrested or being detained has been eliminated. So the client can now take his time to look for a relief that can be Oh, so sorry, my phone froze. I didn't hear the response to my question. What was the question?
Yeah,
I don't
to
know.
repeat it because he didn't post it in full.
Okay, can you please send him a quick message to resend the question? I will still answer the question before I go. I know it's already past 1, but because we started late, that's why I'm also waiting late. The next question: how can I contact my attorney if I'm detained? Well, if you are detained, you will have access to phone. There is, what do they call this? Their phone that they pay for, collect call. Yes, they allow you to use collect call, so you will have access to use the phone. Remember, this is a Western country. The fact that you are detained does not mean that they will block you from access to telephone or anything. Yes, you have access to telephone. You can use collect call to reach an attorney, and you can also reach your family members who can reach an attorney on your behalf. But most important thing is to know your alien number, because like I said, you will not be able to do anything without knowing your alien number. The next question: what should I do if I'm not given access to an attorney? No, it's not possible. You'll be given access to an attorney. The government is not going to pay for it, but they will allow you to have access to hire your own attorney. So they will not provide an attorney for you. They will not pay for your attorney, but they will give you access to hire your own attorney. If they don't do that, that would be a grant to throw out whatever it is that they are bringing up. But I can assure you they will allow you to do that. It's within your right. They are just not going to pay for it or help you look for an attorney. No. So the next question: if the detainee doesn't speak English, will they provide an interpreter? I don't think it is their responsibility to provide an interpreter. You will have to get an interpreter on your own. So if you don't speak English, you have to get your own interpreter. However, if they are going to, if you have engaged a lawyer and the lawyer has scheduled an appointment to speak with you, then the lawyer will notify them that you do not speak English, and in that situation, they will have to provide an interpreter who will act between you and the lawyer. So are we expecting that seems to be the last question. Have you sent a message to him? Because I don't know which one is his question. Can you check his name from the question to see? Yeah, the one that came.
Yeah, I don't think he posted the first part.
Yeah.
I already posted it. I already asked him if he wanted to ask.
Well, our time is up. I actually stayed a little longer than 1 hour because we didn't start early because of the technical difficulties. But right now, I think I've answered the last question. But there's one more question that talk about intervention. We didn't get the full question. The only thing we got is intervention. Can you please resend the question so that I can answer it before we go offline? Intervention. That was the only thing we got. So I don't know what the other part of the questions are. The question is. So next week, by God's grace, we are going to continue this detention series, but we will no longer talk about what triggers detention. We will now be talking about what other options you may have if you are detained. So that is the topic we'll be handling next week. It will be a continuation of what we did today. So is there a response yet?
No.
Okay. In the absence of any other question, I think we will be stopping today. We'll be pausing today. Again, I want to apologize for the initial mix-up. As you can see, we had to improvise, and right now we are using cell phone to go live, just trying to find a way to make sure that we get this program out today. I still don't understand the question. The client that was almost deported. So what was the question?
I don't think he has asked anything. He's just referring to that one.
Okay. Anyway, I think I will explain to him one-on-one. We have to go offline right now. So again, thank you again for joining us. Please join us next week. As I said, this will be a continuation next week by God's grace. We are going to continue this detention series next week by God's grace. Remember to invite your family, your friends, your colleagues at work. Okay. Another question. His question was, if you are removed by error, will they bring you back? No, sir, no, ma. If you are removed by error, you are gone, you are gone. That's it. There is no. The only time that you can be brought back in if you are removed is if you are applying for U visa or T visa. If you are a victim of crime, whether you have been deported or not, if you are eligible for U visa and you are able to get the police certification, you can actually come back to the country. In fact, I've seen a situation where the victim was brought back at US government expenses. He was brought back into this country with US government expenses. What that means is that the government bought his ticket and they brought him back to the country. But that is because he was a victim of crime. So that is the only condition. Otherwise, once you are removed, you are removed. That either by error or by mistake. If you are gone, you are gone. That is why you cannot afford to wait until you get a lawyer, and a good one for that matter. Again, thank you for joining us this week. Remember to invite your family and friends next week. We hope to continue the detention series next week. Thank you. God bless you. This is Dr. Olu Asekun.
Oh, someone just commented.
This is a great opportunity to learn more.
God bless you, Dr. Asekun. God will continue to prosper you and enrich your knowledge.
Amen. Okay. Are we off live now? Are we still live?
Yes.
Oh,
I don't know how
okay.
to stop again.
Oh, let me see.
Maybe on the X.